In this session, we are going to see discharge by breach of contract. That is, under a contract a person has to perform, and if he fails to perform, that is a breach. Contract is made when an offer is made a person to do something or abstain from doing and accepted by another person. If all other requirements of a valid contract are present, like competency contract, free consent, consideration, lawful object, if these things are there, it is a lawfully enforceable contract. A person has to perform. In case he is not performing his part, the law will come to enforce performance. This is breach of contract. If he is not doing, that is a breach. How a person is discharged from breach of contract means that he is relieved of his liability under the contract. He is discharged from his liability under the contract, but he will be liable for damages for non-performance of the contract. For example, if a person has to pay 50,000 rupees under a contract and if he fails to pay, then he is discharged of his liability to 50,000 rupees under the contract. But from that moment, he will be liable for the damages. The same person has to pay something more than 50,000 rupees. If a person has to receive money and if he is not receiving money on that day, what he will do? He will be issuing a legal notice, legal expenses. Then he will be moving to the court. He will claim damages. He will claim interest. So a person's liability, which was 50,000 rupees as on the date of breach of contract, may be 75 or 80,000. The other person will file a suit for recovery of legal expenses, court fee, and his travel expenses, damages, along with the 50,000 rupees. This is how a person is discharged from his liability on breach of contract, but he will be liable for damages and other things for non-performance. This breach may be of two types. This may be actual breach or anticipatory breach. Actual breach means a breach which occurs on the due date of performance. Anticipatory breach, before the due date itself, it is confirmed that this person will not perform. We will take an example. A person has agreed to sell his cow to the other person after 20 days. That is, he has to deliver the cow after 20 days, he has to receive the money after 20 days. If on the 20th day, if he is not performing, it is actual breach. That is, due date has come, the person has not performed. Breach on the 20th day, this is actual breach. Anticipatory breach means even before the due date has come, the person has intimated to the other person that I will not perform my part of performance. We will take the same old example. The seller of the cow may intimate the other person, I am not willing to sell the cow to you. I will be selling to some other person, or I will not sell. Like that he may intimate. The due date will come only on the 20th day. But on the 5th day, the person intimates to the other person that I am not going to perform my part. That is refusal to perform. This is the first one, anticipate. Refusal to perform has been intimated to the other person that I will not sell you the cow, first. Second, by his contact, he shows that he will not perform. The same example, he has to pay, he has to deliver after 20 days. But after 10 days, he has sold the cow to another person. That means by his contact, he intimates to the other person that I am not going to perform my part. Two ways anticipatory breach will occur. One is the person itself refuses to pay. He intimates his willingness not to do his part of performance. Second, by his own contact, he shows that he is not going to perform his part. Two things. When an anticipatory breach comes, what the other person has to do? He has, what are the options? Either he can wait up to the 20th day, then proceed for making a claim. You have not performed, one. Or on the day of anticipatory breach itself, he can proceed that this person has breached and he has not done his part of performance, like that. When one person intimates that I am not going to sell my cows as agreed on the 20th day, on that day itself the other person can treat it as a breach of contract, one. Or he may wait up to 20th day. He may think that this person may change his mind and sell on 20th day. So the other person has two options. One thing, wait up to the due date for performance, or treat the anticipatory breach on the same day as actual breach and proceed against the person. If a person is not proceeding on the day of anticipatory breach, what will happen? What are the circumstances? What will happen? Same example we will take. 20th day, cow has to be delivered. On the 5th day, he intimates that I am not going to perform my part, I am not going to sell to you. This person can take the breach as actual on 5th or wait up to the 20th day. If he is waiting up to the 20th day, what will be the position? We will see. 1. Before the 5th day and the 20th day, he can change his mind and on the 20th day he can perform. That is, this breach, anticipatory breach will not be there. He will be performing on 20th day. That the other person has the chance to perform. 1. Second, some other thing will happen and the contract will become invalid. The same example, he has to deliver on 20th. On 5th day, the seller told, I am not going to give the cow to you. Anticipatory breach occurred on 5th. Performance due on 20th day. This person on 5th he can go for breach of contract and claim damages. And if he is waiting up to the 20th day, something may happen between 5th and 20th. For example, the cow died on 10th day. That means because of destruction of subject matter, the contract becomes frustrated, contract is not valid. So, both the person will not have a claim over the claim under the contract. This is the second one. Third one, the damages will be, if he elects to proceed after 20th day, the damages will be his loss as on 20th day. If he elects to claim damages on the 5th day, on the day of anticipatory, the damages will be assessed based on the loss he occurred on the 5th day. So, assessment of damages for claiming from the other party will be, if he is claiming on the 5th, it will be on the 5th day, and if he is claiming on the 20th day, it may be the other one. This anticipatory may occur on contingency contract also. For example, if a person agreed to marry a girl after his father's death, it is conditional. If father is died, after that he will marry. In case if he marries another girl, even if his father's not died, even before that, if he marries another girl, it is a anticipatory breach. This is a anticipatory. Anticipatory breach occurs even before the actual day for due date for the performance. It will be by refusal or by his contact. The person may proceed on the day of anticipatory breach, or he can wait for the due date for the performance. This is anticipatory breach. Actual breach is the actual due date has come and the person has not performed. This will come when a person fails to perform, or when a person performs part of this. Same example, a contract to sell 2 cows, he has failed to deliver 2 cows, 1. Another one, he fails to deliver 2 cows but he delivers 1. This is a second one. Not performed in full or partly performed, second one. He has not delivered 2 cows, this is not performed in full, no performance at all. Second one, he has partly performed. Instead of 2 cows, he is giving 1 cow. Third one, where the time is the essence of performance, it is not done within the time. For example, a person has ordered milk for a function in the house, a marriage function. He has ordered to deliver 200 liters of milk. But the person has not delivered on the day. If a person comes with the milk on the second day, there is no use. So where the time is the essence of the contract, performance to do within the due date, there is a actual breach. Another one, when one person has to perform and he has not performed his part and the other person cannot do his part. For example, a house to be painted, the house owner has to supply paint and the painter has to do his painting work. If the house owner is not supplying and the other person is waiting to start the painting work, then it is a actual breach. The house owner has not supplied the paint. So this comes under 4 categories. One, not performed at all. Another, partly performed. Third, it is where the time is the essence of the contract. It is not performed within the time. Fourth is the person who has to give something to enable the other person to perform has failed to do this. Then what is the options available for the performance? There's a breach is the person will be compensated. Whatever expenditure he has incurred will be compensated. He will be given something as addition for as a penalty, something will be given extra. One is the actual loss, compensation. Second, giving some more thing as penalty. Third is liquidated damages, where the 2 parties have agreed this will be our damages in case of failure in their contract itself. That is liquidated damages. In case if you are not delivering 2 cows, 1,000 will be penalty. Or in case you are not purchasing the 2 cows, 1,000 will be the damages. If they are entering into a contract along with these things, then 1,000 will be payable. This is called liquidated damages. Liquidated damages is the damages fixed by the contracting people. Another one is penalty, like in case of dishonor of a check by the banker, this will, or in marriage contracts, this will be there to punish the other person. Dishonor of a check will the damages by way of penalty. These are the things for the damages. Next we will see in our next session, we will see how the damages are paid, how the damages are assessed in the next session. Thank you.